Good afternoon and welcome to the Employee Free Choice Act and the American Workforce. I'm Praveen Fernandez, the Associate Director of Programs at the American Constitution Society for Law and Policy, otherwise known as ACS. For those of you who are unfamiliar with ACS, we are a national network of lawyers, law students, and policymakers dedicated to advancing a progressive view of the Constitution, law, and policy. ACS is not an advocacy group, and therefore we do not take positions on legislation. However, we do have a position on meaningful discussion of critical law and policy issues of the day, and that position is we're in favor of it, which brings us to today's panel. While the moderator of the panel will have the privilege of introducing our distinguished panelists, I have the honor of introducing the moderator, Dr. David Madland. While David's accomplishments will take more time than I have here, I'm going to give you a highly abbreviated version, confident that you have fuller details in your bio sheets on your chairs. Dr. David Madland is the director of the American Worker Project at the Center for American Progress. He writes widely on a variety of different economic issues, including retirement, economic inequality, and healthcare issues. In his previous jobs, he's done a variety of interesting things, including working for Congressman George Miller and specifically for his Committee on Education and the Workforce. He earned his PhD in government at Georgetown University and his bachelor's from the University of California at Berkeley. And without further ado, I give you David Madland. Thanks.
Thank you very much. We on? Praveen, thank you very much for having me and for the introduction. I appreciate it. So my job as moderator, let me just sort of set the stage a little bit about the Employee Free Choice Act, give you a brief overview of some of the issues that we'll go over, and then introduce our panel and get to the discussion quite quickly. As I think many of you might know, the Employee Free Choice Act was reintroduced yesterday by Representative George Miller and Senator Harkin. And as you'll hear during this panel, there is significant disagreement about the merits and the provisions of the bill. But a couple of things I think that everyone will be able to agree on in this room is that it's a controversial and significant bill. It's perhaps the most significant change to labor law in the past 50 or more years. And to give you just some of a flavor of the debate from yesterday, when Senator Harkin introduced the bill, he said, quote, "Today is one of the defining moments in history as we introduce legislation that puts power back in the hands of people who are truly the backbone of this economy." But Chamber of Commerce President Thomas Donahue also yesterday was quoted as saying in the Post, if this bill passes, no one is going to add a single job in the United States. So clearly there's disparate views about the bill, and it's clearly going to be a major power struggle. Yesterday, the Chamber of Commerce, flew in about 200 of its members to lobby on the bill. They've pledged millions of dollars to defeat the bill. Similarly, labor unions and other groups have also pledged millions of dollars to support the bill and millions of their members to promote its passage. So clearly, there's different perspectives, but it's an issue that's ripe for the kind of informed debate that ACS is known for. And with that, so that's why we have our esteemed panel to help with that, and I want to thank them and briefly introduce them. You have a full description of their bios, so I will just give a few quick highlights. To my left is Julia Martinez Ortega. She's the research director at American Rights at Work. She's a graduate of UCLA School of Law and the Heller Graduate School of Brandeis University. To her left is Dean Baker. He's the co-director of the Center for Economic and Policy Research. And he's frequently cited in a range of business and popular press on a range of economic issues. He has a PhD in economics from the University of Michigan. To his left is Willis Goldsmith. He's a partner at Jones Day and represents management in a number of industries in all phases of labor and employment law. Before that, he was the firm-wide chair of the labor and employment practice at Jones Day. He's a graduate from NYU School of Law. And I also want to especially thank him because I know when you go into the opponent's territory, it's not always the easiest. So we appreciate that. Thank you. And last but not least, certainly, we have Carol Peer, who is a senior researcher for Human Rights Watch. She specializes in labor rights and trade, conducts fact-finding missions to document labor rights violations, and prepares reports on those findings in the U.S. and abroad. She's a graduate of Harvard School of Law. So the format for today's panel, each panelist will have about 5 to 7 minutes to make a short opening presentation. Then I'll facilitate a moderated conversation among the panelists for about 20 to 25 minutes. And then last, we'll have, I'll turn it over to you in the audience, and you can have about 20 to 25 minutes for questions. So let me start with Julie. Thank you.
Okay, great. Well, first of all, thank you to the Friends at ACS for inviting me to present on this panel about the Employee Free Choice Act, and for even holding this panel. I think the points made are right on, that this is an issue that will definitely brings with it quite a bit of controversy, if you will, and it's a good conversation for us to have at this point in time as we grapple with the economy and the role that workers are going to play in that. It's also an honor to speak alongside Dr. Baker and Carol Peer and Willis Goldsmith and to address such an important gathering. I'd like to start by providing an overview to the underlying law that the Employee Free Choice Act would amend, followed by a description of the bill's major provisions, and then I'll provide some updates on the bill's status and what we're likely to see taking place in this Congress. And let me start with some basics. The National Labor Relations Board is an independent federal agency created in 1935 and is charged with carrying out the National Labor Relations Act, which is a principal statute governing relationships among workers, their unions, and their employers, where those businesses impact on interstate commerce. The Act establishes a 5-member board that is appointed by the President with Senate approval and a general counsel who serves as a government's prosecutor. Individual workers or employers file charges with the agency, and the general counsel determines which of those cases to pursue. There are a few things worth noting about the agency. Perhaps the most important is that the board only awards compensatory damages when the Act is violated. At most, a worker who's discharged from employment in violation of the Act is entitled to an award of mitigated back pay. In other words, the greatest financial exposure experienced by a company that violates the Act by firing a worker is the amount it would have paid that worker in wages minus what the worker managed to earn while waiting for the award. The other thing I will note is that NLRB elections look nothing like elections for Congress or governor. And if the NLRB process were used in El Salvador's presidential election this Sunday, we in the U.S. would almost certainly declare the results invalid and the process fatally flawed. I've distributed on everybody's chair a chart describing the tenets of a free and fair election and comparison of those to the NLRB elections. I'd encourage you to take that back and take a look at it. Now, a few words about the Employee Free Choice Act itself. It has 3 provisions. The first provision establishes a clear blueprint for negotiating a first contract. Presently, only about half of newly formed unions are able to negotiate a contract within 1 year of bargaining. Contrast this with Canada, where only about 8% of new unions lack a contract after 1 year. And Canada has statutory language similar to that proposed in this bill, which provides that if the parties are unable to reach a contract, either party can request mediation to move the process forward. If that mediation is not fruitful, then either party can request that an arbitration panel be seated to render a first contract, which can subsequently be modified by mutual consent of the parties. Much has been said about the rush that the parties will be under to reach a first contract if this provision becomes law. These concerns stem entirely from a misreading of the bill. I've distributed on your chairs as well a text of the bill, and I encourage you to read along on Section 3H, Parts 1 and 2 for yourselves. I think a big part of our job when talking about this bill is to dispel many of the myths that are out there about what the bill contains. As you'll see by reading the bill allows either party, either the management or labor, to request mediation after 90 days of bargaining on their own. It does not require a party to request it. If all is going well in negotiations, the parties are free to continue their work indefinitely. The same is true for the other phases of bargaining. Also, you can see that the law imposes no time limit on how long the arbitration panel would have to examine the evidence or deliberate. Research by Dr. Riddell of Queen's University School of Policy Studies indicates that Canadian unions who operate under similar law rarely require the use of a third-party arbitrator. And when they do use a third party, it is very rare for the arbitrator to ever have to render a contract because the parties almost always come to an agreement on their own. The second provision of the Employee Free Choice Act provides for increased penalties. It would allow for treble damages on back pay awards for firings or other discrimination with a financial impact that occurred during the organizing or first contract periods. In addition, any employer who willfully or repeatedly commits any unfair labor practice during organizing or first contract negotiation could be subject to a civil penalty in an amount not to exceed $20,000 for each violation. I won't go into the number of workers who are fired or otherwise coerced during organizing campaigns, as Dr. Baker will cover this area. Suffice it to say that these sorts of violations are all too common. And the bill is a very modest attempt at addressing the lack of teeth in the current law, and for many employers, $20,000 will still not have a significant deterrent effect. Despite this, the American Enterprise Institute just recently released an issue brief characterizing these penalty increases as draconian new penalties. The third provision, and perhaps the one that has garnered the most attention, is designed to streamline union certification. Under current law, the employer can refuse to recognize the union even if 100% of the workers have signed documents indicating that they want to form a union, and even if the employer has no basis for believing that the signatures are invalid. This is referred to by some as the employer veto of the workers' demand for recognition. The bill would require that the NLRB investigate the signatures and the method used to obtain them. And if the board finds that more than 50% of all workers, in fact, did want to form a union, then the workers would be certified as a union, hence the reference to majority sign-up. This provision is also referred to as card check because presently workers often use cards provided by the union to collect legally binding signatures from other workers who also support the union. Now, a critique of this approach is that workers would not be able to hear the company's arguments against forming a union, and that union supporters will somehow bully or coerce their coworkers into signing legally binding documents indicating that they want the union. Assuming arguendo that you believe the employer's arguments on the matter should have bearing, the peer-reviewed objective research points to substantial coercion of workers by management as the workers seek to make a decision, and scant reporting of coercion from fellow workers. The same study showed that the vast majority of card signers in card check campaigns felt that they had enough information to make an informed choice. Much has been made about the Wild West environment that would be created as pro-union workers attempt to persuade their fellow workers to sign cards. However, it's important to remember that current law already requires workers to collect cards from their coworkers indicating that they support forming a union. This is the very step, it's the basis on which workers are then able to submit a petition to hold an NLRB election. Under current law, workers must collect signatures from their fellow workers indicating that at least 30% of their fellow workers want to form a union in order to support that petition for an election. They do this card collecting on their own. Sometimes they do it with and without the management's knowledge that they're collecting these cards, but never with the NLRB agents personally observing the card collection. That's current law. That's the way the law works now, without the bill. When an NLRB election takes place, there is no board agent present on the ground anywhere near the workplace until the day that he or she arrives to set up the voting booth. However, regulation of the card collection process does occur, and there's a well-developed body of law that is used by the board, and there is clarity over what remedies are available for violations by overzealous pro-union workers or union organizers. To put it more directly, the exact same processes that have been used for decades to determine workers' interest in forming a union would be used now under EFCA. Concerns that somehow a business owner would not know if an organizing campaign was brewing and therefore would miss out on the chance to tell his workers that he opposes the union are misplaced, and they indicate a fundamental misunderstanding of the current law. The vast majority of non-supervisory workers already have the ability to form a union under the protection of the NLRA. Current law allows employers to post anti-union signage in the workplace, to include anti-union language in the personnel policy or handbook, to hold mandatory meetings in which arguments against union formation are made, and the workers can be prohibited from asking questions or countering any anti-union statements. Management can do this even if there is no ongoing campaign underway. All this is allowed and will continue even if the Employee Free Choice bill passes. The only thing that would change if the bill passes is that workers would determine whether to indicate their interest in a union one time or two times. Now, the American Enterprise Institute also argues that under this bill, the NLRB would, quote, go the way of the buggy whip. And I think this is a great metaphor because we all know that buggy whips are not prohibited by federal law, nor are there any state or local prohibitions on their use when driving one's buggy. However, with few exceptions, people have chosen newer, more effective forms of transportation like cars and metro rails to get around town. Because of this, a whole host of rules and regulations have become necessary to govern our driving and use of the roads. Like our transportation systems, labor management relations have changed as the balance of power has been skewed toward management. Like our transportation laws, our labor laws must change to keep pace with changes in the labor management arena. Indeed, from 2003 to 2008, more workers formed unions using majority sign-up than through the NLRB's election process. The Employee Free Choice Act would modernize our labor laws to keep pace with the reality of today's workplace, and America's workers need for Congress to pass it quickly. And I'm going to close with just a few notes about the bill's status, just so that people understand. The bill was introduced back in 2007 in the 110th Congress. It was passed there. Okay, by a vote of 241 to 85. To refresh people's memory, there were only 51 votes for cloture, and so the bill never went anywhere in the last Congress. We're very hopeful that in this Congress there is going to be some real progress made on the bill. Thanks.
Thank you, Dean.
Thank you. I'm going to say a little bit about some of the economics around this because there's obviously the debate has grown very rapidly recently. So what I first want to say is talk a little bit about the evidence on unemployment and unionization, what the links are or non-links, as I'll argue. Secondly, a little bit about the decline, the reasons for the decline in unionization. I have a lot to say, but just sort of make an obvious point here. And then the third thing I want to talk about is my actual reason for being here, and that's to talk about a study done by my colleague, John Schmidt, about the likelihood of workers being fired in a unionization drive. Okay, on the first point, there's been a real effort to try to claim that unions are associated with high unemployment, that they cause unemployment. And I've sort of been struck by this because there's been a lot of research on this topic. It's one of the more heavily researched areas in economics. And the bulk of that research has really gone in the other direction. If you went back 10 or 15 years ago, probably most economists would have said that unions are associated with unemployment, kind of like if you go back, say, 15 or 20 years ago, most economists would have said that the minimum wage leads to unemployment. Economists who are familiar with more recent research know now that there's a large body of research that shows that the minimum wage does not lead to unemployment. So those who are up to date with current research would not say that. Well, it's the same story with unions and unemployment. There's been a lot of research on the topic, and I think that the best study was done about 2 or 3 years ago now by the OECD, where they reviewed a wide range of studies, did their own work, and came to the conclusion that unions are not associated with unemployment. Now, of course, you could find countries that have high unionization rates, have high unemployment, but you could also find countries that have very high unionization rates, in particular the Nordic countries, Sweden, Denmark, Norway have unionization rates on the order of 80%, and they typically have lower unemployment rates than ours. Denmark, until this crisis, had an unemployment rate of 2%. They're very worried they didn't have enough workers. So this idea that unions create unemployment, I think, it's simply not borne out by the evidence. And I know this will come back again and again and again, and obviously people make claims on it, but I think the most recent evidence simply does not support that. Second point, one indisputable fact is we've had a rapid decline in the unionization rate in the country over the last 3 decades. And as most of you are probably aware, the private sector unionization rate is about 7% now. Now, many people who are opposed to the Employee Free Choice Act have argued, well, the reason why we have a decline in unionization rate is, well, unions are, this is all 19th century or 20th century. This is another era. People don't want unions today. Well, the obvious counter to that is we have a very large experiment called the public sector, where employers can't freely fire workers who want to organize. And what's going on with unionization rates in the public sector over the last 3 decades? Well, basically nothing. In fact, it's probably going up a little bit, depending which years we want to choose. But if we look at the unionization rate in the public sector, it's about 36% today. If we go back 30 years ago, it was about 35%. If it were the case that unions don't fill needs for workers, we would expect to see something comparable going on in the public sector. We'd expect to see a decline in the unionization rates in public sector. I know many public sector workers. My mother was one. They're not qualitatively different than those of us who work in the private sector. So it's a little strange that if this were just workers' choice, wouldn't we expect to see something going on among the 22 million people who work in the public sector? We see zero. That's a very large sample, and we see zero. So I think there's a pretty clear case that what's going on is not that workers of their own volition decide, I don't want a union. What's going on is employer hostility, and much greater hostility to unions today than was true 30, 35 years ago. Which brings me to the last point. I'm filling in here for my colleague John Schmidt, who just released a study that he did with another coworker, Ben Zipper, which updates an early study that looked at the probability of being fired in a union organizing drive. The earlier study took a look at the probability for individual workers being fired in a union organizing drive and found that 1 in 5 workers end up being fired. And the logic of that is what you had just heard, that the sanctions for being fired are very, very small. So an employer will often make the calculation that, okay, I could go ahead and fire a worker, and the risk, maybe I will get, it'll be overturned by the National Labor Relations Board. The cost of that is very small. If that's sufficient to blunt a unionization drive, because the workers see all the leaders are fired, well, that's probably a good deal for me. So employers make that decision routinely, and again, by the calculation they came up with, looking at actual instances where the National Labor Relations Board had reinstated workers, so that was the assessment that they'd been fired for their organizing, they concluded that 1 in 5 union organizers were fired in the course of a campaign. The updated study takes a look at the percentage of unionization elections that are marred by a firing. And again, using a very similar procedure but counts elections rather than workers, it reaches the conclusion that 1 in 4 elections are marred by a firing. So the point of this is that this is not a rare occurrence. It's in fact the norm, that workers, when they take the initiative to try to organize a union, when they go talk to their fellow workers, they have a very, very real fear of being fired. So this is not a free election. This is not President Obama running against John McCain, and they go out and make their arguments, and their supporters get out and make their arguments and pass around literature. It's a case where Senator Obama's workers can all get fired, or Senator McCain's workers could all get fired. That's the sort of election we're talking about today, and that's the reason why we need a serious reform of the labor law. So I'll stop with that.
Thank you.
Willis?
Yeah, thanks, David. And to your introductory comment, I'm beginning to take it as a point of personal pride that on each of these ACS panels that I've been on, and I think there are at least 3, it's always been 1 against 3. So I'm assuming that there's a reason why that's the case. And I'm, as I said, take personal pride in that. Having heard Julie and Dean, I'm not exactly sure that they're talking about the same National Labor Relations Act that I've been involved with as a management labor lawyer for the last 35 plus years, but maybe we'll get to that in the question and answer session. I do think that, and I agree completely with what David said at the outset about this being a very important piece of legislation. It's noteworthy for any number of reasons, not the least of which is because at least for the first time in my 35 plus years as a management labor lawyer, there is absolute unanimity in the management community. This never, ever happens. There's never anything remotely resembling unanimity in the management community on any piece of legislation. There is, however, unanimity here. There is unanimity among management labor lawyers on this piece of legislation, and I think it's obvious that unanimity is opposed to the statute, and I'm going to get to some of the reasons why that's the case. And the unanimity actually, I think, goes beyond management lawyers and the management community. I mean, for heaven's sakes, I was having my annual physical last week, and my doctor, who's supposed to be paying attention to me, he knows what I do for a living, in the middle of the physical, he said, "Isn't this card check thing just awful?" And I said, can we get back to me, doctor, and then we could talk about card check later. Look, this isn't about economics. This is about union density. There is no question that union density in the United States has been declining steadily for decades. There are any number of reasons why that's the case. Globalization, demographics, perhaps even the quality of union organizers. The union organizers not being able to sell the proposition to people they're trying to organize that being in a union is actually going to add economic value to the company such that their jobs will be protected. One only need look at the multiple industries that have been having problems for years, whether it's auto, whether it's steel, whether it's newspapers. These are heavily organized industries that for years, jointly with unions and employers, for whatever reasons, have been having serious economic problems. Dean made reference to the public sector. It's absolutely true that public sector employees are not qualitatively different than private sector employees. However, public sector employers are qualitatively different from private sector employers for the obvious reason that private sector employers actually have to compete in the marketplace. Public employers don't. Union density. Now, there are a number of premises underlying the Employee Free Choice Act, but they can be distilled, I think, into several kind of key concepts. One is that employers are bad. A second is that unions are good, and that it's always good for employees to be represented by a union. And implicit in all of that is that there's no real reason why an employee ought to hear the employer's perspective on whether or not being represented by the union is a good thing or a bad thing. It assumes that any responsible employer should be open to having its employees recognize a union and have the employer engage in bargaining. So I took a look at a couple of publications who annually put out lists of the best places to work for one thing or another. While I did some research on this, it's not entirely scientific, but I think it's quite accurate. In Black Enterprise, their last survey in July of 2008 of the 40 best places to work for diversity purposes, 23 of the 40 were either totally non-union or largely non-union. Diversity Inc., of the top 50 companies for diversity, 32 of those 50 companies were either totally non-union or largely non-union. The National Association for Female Executives has two categories, the top 10 for female executives and then the top companies. In the top 10, 9 out of 10 are either totally or substantially non-union, and of the remaining 15, 13 of those companies for female executives are either non-union or largely non-union. And this doesn't address entire sectors that are non-union, like the high-tech sector, Microsoft, Google, Yahoo, Hewlett-Packard, places where people think there are great places to work for a lot of obvious reasons. I assure you that those employers voted by those magazines based on surveys that they take are not non-union or largely non-union by accident, nor are those employers malevolent employers. These are employers who provide very good working conditions, very good pay, very good benefits, the kinds of places where people want to work. The employers are bad component of the reasons that EFCA is being proposed. Really are based on a couple of studies, and Dean mentioned one, and I was going to say, fortunately, I'm not an economist or a statistician, but in any event, I'm not an economist or a statistician, not an actuary either. So that's good, I suppose. Look, I've looked at a lot of economic studies in one context or another over time. I've certainly cross-examined a lot of experts in various areas in various kinds of trials, bench, jury, administrative, and what have you. And we all know that there are studies that go one way, and there's always going to be a study that goes the other way. And it would take more time than any of you have to go through every single flaw in the studies that are most often relied upon to support the proposition that EFCA ought to be passed. What I would say is that if you look at Professor Epstein's long article on why EFCA should not be passed, Professor Epstein at the University of Chicago Law School, you can see a debunking of most of the studies, statistical studies that address any issue that relates to EFCA. And Justin Wilson of the Center for Union Facts has taken much more relevant and recent NLRB data and come up with his analysis, which I'm going to get to briefly, explaining what is really the statistical situation with respect to the number of employees fired in the context of organizing drives. Now, I know people are going to say, well, look, Epstein's got a particular point of view. Wilson has a particular point of view. Well, of course that's right. But so do the proponents of every other study on the other side. So, we can kind of put those aside. But I do want to focus just for a second on the study that Dean mentioned. That it's called Dropping the Axe, and I've taken. I think it is thoroughly undermined by the studies that I mentioned. But let me just read to you a couple of the premises of the study as originally promulgated. I haven't read the one that's I think very recently, within the last week or so. Okay. But you can correct me if I'm wrong. I don't think that what I'm about to focus on has changed. I'd be surprised if it's changed, but if it has,
You can finish up in a minute.
There are three of them, and there's only one of me.
We will definitely get you a chance.
All right. Well, maybe I'll come back to the study, and let me just read one sentence. In the summary of the study that Dean referred to, it says, if we assume that employers target union organizers and activists, and that union organizers and activists make up about 10% of pro-union workers, our estimates suggest that almost 1 in 5 union organizers or activists can expect to be fired as a result of their activities in a union election campaign. Not a single piece of empiric evidence to support any of that. I don't even know what a union activist is. I mean, how active do you have to be an activist? Many union activists in the course of union organizing drives actually wear T-shirts that say, I'm a supporter of the union, to insulate themselves from being fired. Common tactic. Why would you assume that it's about 10% of pro-union work? Why not assume it's 5%? Why not assume it's 50%? So these are just bald assumptions, and they're replete throughout this study. Look at the real data. The real data is now from the NLRB's case activity tracking system, which shows, based on a breakdown of unfair labor practice charges and a reflection of how those charges figured into organizing campaigns, that approximately 3.75% at most of organizing drives involve the discharge of an employee. I have a lot more. We'll get to it later.
Thank you very much.
Let's finish with Carol. Thanks.
I also want to extend my thanks to ACS for organizing this very timely panel. And I want to wrap up by suggesting that when we talk about the Employee Free Choice Act, we're not fundamentally talking about questions of union density, and we're not talking about questions of the efficacy or lack thereof of labor leaders. What we're talking about is a question of basic human rights. U.S. labor law and practice currently fall far short of international human rights norms on freedom of association, and the Act is absolutely essential to begin to remedy the weaknesses, at least in those 3 key areas that Julie mentioned at the beginning of this panel. So first, to begin with, the weak remedies and delayed enforcement. As Julie noted, employers under current U.S. law who are found guilty of committing an unfair labor practice presently face no punitive consequences and few, if any, negative economic repercussions for their wrongdoing. Lengthy enforcement delays, often lasting for years, further undermine the weak penalties that the law provides. And although the National Labor Relations Board has discretion in the most egregious cases of employer anti-union conduct to petition a federal district court for an injunction, it's called a 10J injunction, to stop the alleged illegal activity until a legal judgment can be rendered in the case, the board rarely does so. And in contrast, I find this particularly interesting, U.S. labor law requires the board to seek a similar injunction on behalf of employers in cases of especially egregious charges against unions. So what does international law say on this issue? It says that anyone whose right to organize has been violated must have, quote, an effective remedy with, quote, sufficiently dissuasive sanctions against illegal conduct. Redress for anti-union discrimination must be, quote, expeditious, And laws must provide, quote, efficient procedures to ensure their implementation in practice. And specifically condemning U.S. law's disparate approach to egregious illegal employer conduct versus egregious illegal union conduct, this mandatory versus discretionary injunction situation that I described, the ILO Committee on Freedom of Association, which is the ILO body that is charged with hearing complaints against ILO members for allegedly failing to protect workers' right to organize, this committee has stated that, quote, workers and employers should be treated on a fully equal basis, in particular with respect to unfair labor practices. And that was in a case against the United States specifically. So it's abundantly clear that the current system that we have in the United States for enforcing U.S. labor law through weak, slap-on-the-wrist penalties that are generally applied years after violations occur falls far short of what is required by international standards. So the stronger penalties that Julie described that would be available under the Employee Free Choice Act, including the requirement now that the NLRB seek an injunction if it believes an employer engaged in particularly egregious anti-union activity, are really a human rights imperative. Secondly, moving on, the Employee Free Choice Act would indirectly address the unfair, slanted union election rules that Julie and others have discussed today. Employers, as she mentioned, can currently force workers to attend anti-union captive audience meetings during work time, and they can prohibit union advocates from holding parallel meetings to respond. Employers can campaign vigorously, aggressively against union formation throughout the workday, through casual comments, one-on-one meetings, group meetings, and the like, and they can bar union organizers from the workplace. And in most cases, employers can hand out as much anti-union literature and propaganda that they like while preventing union representatives from distributing information anywhere on company premises, including the parking lots, sidewalks, and the like. Employers can guarantee themselves ample opportunity to take advantage of these slanted rules by refusing to recognize a union based on card check and demanding instead an NLRB election. The pre-election period, is really all the time that employers need to mount their aggressive anti-union campaigns, including unlawfully firing workers who are supporting the union or engaging in pro-union activity, thereby undermining workers' right to organize. What does international law say about the current state of U.S. union elections? Well, in a case against the United States, the ILO Committee on Freedom of Association specifically found that workers do indeed have a right to receive information from trade union representatives in their workplaces, and explicitly asked the United States, quote, to guarantee access of trade union representatives to workplaces so that trade unions can communicate with workers in order to apprise them of the potential advantages of unionization. Now, the United States, of course, ignored this ruling. But a larger question is, what about an employer being allowed to file an election petition in response to a union's demand for card check recognition? International law actually doesn't stipulate the specific procedures that must be available to workers attempting to exercise their right to organize. But the ILO Committee on Freedom of Association has said, quote, the formalities prescribed by law for the establishment of a trade union should not be applied in such a manner as to delay or prevent the establishment of trade union organizations. And of course, as we've heard and as we all know, that is precisely employers' intention in many cases when they deny union recognition based on card check and instead petition for an NLRB election. So, although not problematic on its face, given the broader context of weak U.S. labor law, the U.S. labor law provisions that do allow employers to reject card check petitions do in fact run afoul of international standards. The Employee Free Choice Act would not fix the slanted union election rules that I've described, but it would at least help mitigate their negative impact by requiring employers to recognize a union based on card check, thereby eliminating that pre-election period during which much of the aggressive anti-union campaigning occurs. Lastly, the issue of collective bargaining. Finally, the Employee Free Choice Act would begin to remedy U.S. labor law's failure to effectively protect workers' fundamental right to bargain collectively. As a result of the weak remedy system available under U.S. labor law, if an employer is proven to have engaged in illegal bad faith bargaining, the remedy is really just more bargaining, because what happens is the employer must post a notice in the workplace promising no more unlawful conduct, and then the remedy...
Carol, if you could finish up in about a minute. Thanks.
Sure. And then the remedy is to go back to the negotiating table, where the cycle of bad faith bargaining can simply begin again. Obviously, with this feeble remedy, there's little incentive for employers to comply with the law by trying to reach an agreement if they don't really want to in the first place. International law not only recognizes workers' right to collective bargaining, but provides that the enjoyment of this right necessitates, quote, that both employers and trade unions bargain in good faith, making every effort to reach an agreement. It also demands that countries take the measures necessary to, quote, encourage and promote the full development and utilization of machinery for collective negotiation. As Julie mentioned, the Employee Free Choice Act would at least begin to fix U.S. labor law's failure to meet the standard on collective bargaining. Thanks.
Thank you, Carol. So as you heard, there's not a lot of areas of agreement. Sometimes in other panels there tends to be a little bit more agreement, but I'm going to first just sort of kind of highlight a few of the areas of disagreement, because I don't think we got to fully flesh them out, but also I interrupted Willis as he was trying to sort of highlight one of these areas, but I also think it's just a fundamental. Seems to be a dispute about facts that we should highlight, and kind of this Willis was phrasing it as whether employers are bad or unions are good, and that's sort of a little bit too broad. What I'd like to focus on is sort of in the context of organizing, really who's doing the action here that we're trying to limit. Willis was making the argument, in contrast to the other three, that really there's very little harassment or intimidation, whereas the others seem to be making the claim that there's significant. So I start with Willis, but then I'd like the others, especially Dean, to also respond to his study was critiqued.
Okay, let me respond to that, David. Let me just go back to try to clarify a few things here. Look, this is, in a sense, all about speech. And the way the statute works is this way. There are constraints on what an employer can say at any time, but especially in the laboratory conditions. That's a term of art, comes from a Supreme Court case, that must surround an election campaign. Employers cannot engage in coercive speech, threatening speech, and so on, and they are subject to sanctions, however you want to describe them, for having engaged in that kind of speech. There are no constraints, none, on unions in the context of an organizing drive, which is always an issue, because a union can go and organize a group of employees and say, I will get you a 50% wage increase. Totally made up, no sanction, right? So that's an important speech issue, and it's important, as the courts have recognized, including a case that I argued in the Supreme Court last term, that employers have a statutorily protected right to engage in non-coercive speech. That's a given, and I would hope that in this country that will always be a given. Now, in terms of access, it is just, it misstates what the law is to say that union organizers are barred from workplaces. That's just not true. Non-employee union organizers, absent certain circumstances, are barred from a workplace. That means that if you don't work for the company, but you just want to come in and organize, the employer doesn't have to let you in. That's a fundamental property right that's been recognized by the Supreme Court for decades. Employees who are union organizers are totally protected in the workplace. They can distribute materials in non-working time in non-working areas. They can talk to employees. They can do anything they want to try to organize within the bounds of this carefully constructed law that we have. So there's just no question about union organizers who are employees having certain rights. Look, the secret ballot issue, and I'm not enough of maybe I'm not at all an international law expert. I do know something about the statutes in various companies. The secret ballot issue, this is really ironic. There have been members of Congress who are vocal supporters of this bill, EFCA, who have complained that there are no secret ballots in Mexican elections. They have written, Barney Frank wrote a letter complaining about that. Lance Campa for Human Rights Watch. Let me just read you what he said, because I think it's really important, and it just shows that this really is just about something other than economics. Lance Campa, who I knew from when he was a negotiator for the Newspaper Guild. Perhaps over time, the U.S. system could evolve toward a generalized acceptance of the card check system. But in American culture now and for the foreseeable future, this is in 2000, fairly run secret ballot elections still have a, quote, moral primacy. Workers, employers, and the general public see their outcome as more legitimate. Human Rights Watch believes that secret ballot elections should remain a standard method of determining workers' choice whether to bargain collectively with their employer. Same time, experience demonstrates that where workers and employers can agree to use card checks with safeguards, fine. Safeguards against coercion by management, by union representatives, or by coworkers. And you know, this continues. I mean, I just picked up in the paper 2 days ago, right? And this is the last piece I'll say on secret ballots. This is an article in the New York Times, March 9th, 2009. Grip of the mob is gone in this race, a union says. This is the union representing New York City school bus drivers. March 9th, page A18, I think. On Monday, a new era may begin for the union, Local 1181 of the Amalgamated Transit Union, as its roughly 15,000 members prepare to vote by secret ballot in what members say would be the first election free of mob influence in 30 years. Instead of installing leaders without a vote or intimidating union members into voting for preferred candidates, union officials will oversee the mailing of ballots and so on. Nobody gets intimidated, said John Bisbano, a school bus driver for 15 years who is running for union president on one of several competing slates. You do it from home. The last thing I'll read from the article, the privacy precautions surrounding the union vote may seem unusually strict, but for a local that has held fewer than 5 executive elections since the late 1970s, voting by secret ballot is widely seen as the first chance in a generation for the union to clean up its act. This is 2 days ago. Of course, secret ballot voting for union officials is required by statute. That's what the Landrum-Griffin Act says. You can't elect. A union cannot have an election of officers without doing it by secret ballot. The idea that secret ballot is somehow a bad thing and that it's better to have people being put, however often, in the position of being coerced or intimidated is just, to me, rather stunning.
Julie and Dean, find out who goes.
Well, I'll just quickly say, I mean, I think the issue here isn't about secret ballots in and of themselves and whether they are valuable or worthwhile. The question is, are secret ballots alone enough? If you have a secret ballot that takes place, a balloting that takes place at the end of a long series of what really is a complete election scenario, you need to look at that full context of everything that leads up to the day of the vote. That secret ballot, itself at the end cannot rectify serious flaws that take place along the way in the process. I mean, the example that a lot of people, throw out on who are supportive of the bill is, Saddam Hussein was elected the leader of Iraq multiple times using a secret ballot. I don't think any of us in this room probably think that those elections really meant a lot or that the people there really wanted to, support him. And so I think the argument that a secret ballot, it just becomes sort of a red herring in this. And again, I take you back to the material that I passed out that really, we don't have time to go through the whole sort of schematic of how a union election actually looks. And I should even add, this is a schematic of what it looks like under perfect laboratory conditions, not how it really plays out with the realities. And so I think that's an important distinction to be made.
Okay, just a couple things. I'll get back to my study in a second. But just as well as Will knows, workers are not guaranteed a secret ballot election today. It's up to the employer. What the main change in the Employee Free Choice Act is it gives the workers the choice as to whether they want to organize through a secret ballot or through majority sign-up. That's the main change. So if he's upset about the sanctity of the secret ballot, he should be jumping up and down yelling about the current situation because workers are not guaranteed the choice of a secret ballot. In fact, unions have been decertified through majority sign-up. So obviously that's not the concern here. That's simply invented. Now getting back to the study, first off, It's kind of funny. You don't know what a union activist is. I sort of feel like I have Sarah Palin here saying I don't know what a community organizer does. A union activist. The assumption that my colleagues made on this, we have data on what percent of people, the numbers of people who were fired in union organizing drives. We know how many people were fired in union organizing drives. We know how many people indicated they supported the union in an election. So we're trying to compare A to B. We have that number. Then we said, let's assume that employers don't randomly fire people who support the union, that they, since they're trying to prevent the union from coming into existence, they're most likely to fire the people who are actually organizing. So yes, 1 in 10 was the number that we pulled out of the air. It could be that 1 in 8 are actively organizing. It could be that 1 in 20 are actively organizing. But the point is, not everyone there is actively organizing, and we're giving employers credit. Maybe they're stupider than that. But we're giving them credit that when they're trying to prevent a union organizing drive, they focus on the people who are organizing, not someone who's hiding in the back and just, they're going to go vote, but they're not doing anything. Now, the final point I was just going to make on this, in terms of the methodology, talking about studies that were just out last week, in terms of determining the percentage of people that were fired in the context of a union organizing drive. We have the numbers from the National Labor Relations Board, how many people who were fired for union activity and were reinstated. The question is, what percent of those were done in the context of an organizing drive? We're following 25 years of research, one Harvard Law Review study, a second by 2 University of Chicago law professors back from the early 90s, the Dunlop Commission. This study that was done by the Center for Union Facts came out a week ago, 2 weeks ago. We'll look at that. We'll look at that and we'll find out what they did wrong, and we'll let you know. But I'm willing to go with 25 years of research by the experts in the field. We'll look at what the Center for Union Facts came up with, I promise you. But for the moment, at least, I'm willing to accept what the experts in the field were willing to follow that over what they've done over the last 25 years.
And then, Carol, I know she wanted to jump in.
Yeah, I wanted to address a few of the points that Willis raised. First of all, the Mexico argument, because I've heard it over and over again, and it's extremely disingenuous, because in Mexico, when there is no union in a workplace, organizing occurs through a card check process. There is an election if workers want to unseat an existing union. And the choice is between a secret ballot election or an election in which you vote in front of your employer and usually hired thugs paid by your employer who opposes the unseating of the existing union, because in Mexico, in many cases, an existing union is a pro-employer, what's called a yellow union. So an election in which you have to indicate whether or not you want the union unseated in front of an employer who you know can fire you if you vote in favor of a new union, and in front of hired thugs who you know can beat you up if you vote in favor of unseating an existing union. So given that choice, yes, we do support a secret ballot election versus an open election in which you have to publicly indicate that you want a different union and risk being fired or risk being beaten up. So that's the Mexico scenario. Human Rights Watch did publish a report in 2000 in which, written by Lance Campa with the quote that was read. However, that report also included a lot of recommendations with regards to amending the unfair union election rules that are currently in place. None of those have been implemented in the 8 years since that study came out. As a result of the failure to implement those recommendations, Human Rights Watch has taken the position that in order to ensure workers' right to freedom of association in the United States, we need a choice between a secret ballot election or another way of organizing, which is the card check process. Willis is absolutely right that workers have a right in their workplace to distribute information on non-work areas and non-work time about unions. Employers can talk about their opposition to unions during work time wherever they want in the workplace. And they can bring in hired outside consultants, which many, many do, to try to defeat union organizing. There is a whole cottage industry of outside consultants who specialize in preparing anti-union videos, anti-union presentations, PowerPoints, and the like, and many employers hire them to come in and give presentations to their workers. So employers can bring in outside sources in the context of an organizing campaign. workers who are trying to organize themselves cannot bring in their expert, an outside union organizer, to similarly respond and present the, quote, other side of the story.
Willis, I know you were going to try to jump in. I'll just give, if you can be quick, and then so I can get to another question.
I'll do this quickly. No, where the unions respond to what the employers do in the workplace is to go where the employer can't go, because the unions can go and talk to employees in their homes, in any place they want to, without the employer having any knowledge at all about the discussion, without having any knowledge about promises, without having any knowledge about threats. But fundamentally, this is all about speech, and the notion that somehow employees ought not to hear both sides of the story, which is what EFCA is designed really to set up, given how it works. I mean, it's bizarre. I mean, you campaign in private and you vote in public. I mean, how can that be in this country? So there's plenty. It's just about speech, and why shouldn't employees have the right to speech? They should not be coerced. They should not be intimidated. There are thousands of cases that address employer violations along those lines. On the study that Dean mentioned, again, this is why this is probably better for cross-examination. The two studies are the Weiler study that was done in 1983, the Bernie Meltzer study with Lalonde was done in 1991, and that was a large sample. That was 202 cases in the Chicago regional office of the NLRB in 1955 and in 1980 that led to maybe it was 88, that led to this 51% number that's since, I think, been completely debunked. But I don't think it really pays here to do that. Can I just make a few comments about first contract arbitration? And
we'll get to that.
We'll get
to that later. There were a couple of points that were both brought up here about sort of there's some rights that that people are talking about, that whether it's employees' right to join a union, but also whether free speech rights, both of union organizers and employers. So I guess I'd want the panel to comment on the balance that's currently struck versus what the proposed law, Employee Free Choice Act, would do if it gets it right, sort of where we are there. Because originally, sort of the Wagner Act was much more towards employer neutrality. We see today where, although there are certain things employers can't say, they have significant abilities to give their side of the story. So I guess I'd like the panel to comment on sort of striking the balance, and can start with Carol, because she talked a little bit about this in the sort of international context.
Sure. I mean, I think one important point to reiterate is that the Employee Free Choice Act does nothing to limit employer free speech. I mean, employers would still have the opportunity, as I'm sure many will do if the act passes, to state their views about unions from the moment workers are hired. I did research over the course of about 2.5 years looking at violation of workers' right to organize in the United States by Walmart. When you are hired at Walmart, part of your orientation process is to see an anti-union video. There is nothing in the Employee Free Choice Act that would ban the anti-union video. It would simply, the Employee Free Choice Act would simply take away the pre-election campaign period during which much of the aggressive anti-union campaigning that undermines workers' right to organize occurs. Employers would still be able to, throughout the workday, whenever they want, express their views on union formation. And I think an important point to note, as I said earlier, is that workers do have a right to receive information about the possible benefits of union formation. And under the current structure of U.S. labor law, that right is severely limited. The ILO Committee on Freedom of Association, as I said, has explicitly told the United States to amend its law to allow union representatives to have access to the workplace, just as anti-union consultants currently have access to the workplace. And the United States has ignored that ruling. So we currently have a situation in which the balance is slanted very heavily in favor of employers. And the Employee Free Choice Act would only slightly tilt the balance back, I guess, towards. I wouldn't even say it would make it an even playing field. It would help. It would help, but employers would still have the ability to engage in their free speech anti-union campaigning.
Willis, you want to respond?
Do you see the irony here? I mean, one of the big complaints that supporters of EFCA have is this whole notion that what are called 24-hour speeches, the proponents of EFCA like to call them captive audience speeches. These are the speeches that employers will not always, but often give to employees 24 hours or just before 24 hours before an election. What EFCA does is basically, and this is, I think, what Carol was implying is perfectly okay, but I'm suggesting it's probably not the best thing that would happen in the American workforce, is there would be a perpetual, ongoing, never-stopping organizing campaign. I mean, that makes no sense at all. The union under EFCA doesn't have any obligation to say we are now beginning to organize your employees. Under many voluntarily entered into neutrality agreements and card check agreements, there's a clock that starts where the employer and the union agree that today we're going to start an organizing campaign, the idea being that everybody's point of view gets out. Under this scheme, employers who have, again, non-coercive, non-threatening, but messages to deliver that have to do with whether or not a union is good for their business are going to be forced to do this 24/7, which can't be a good thing. So I would obviously take a very different view of this.
All right. I want to talk a little bit about sort of timing and ask our thoughts, because there's sort of a couple of arguments that are floated from both sides about both because of sort of the state of the economy, that's a good reason or not a good reason to support this bill, pass this bill now, and similarly about the politics with the new Congress, new president, whether the timing makes sense to go forward now, or should we wait? So I'd like to start with Julie, but then I'll go down the panel.
I guess I would just say, and I'm going to mostly leave this to Dean to really address, but I think that it goes without saying that helping workers right now at this time with the economic crisis is probably one of the most common sense approaches that we could do in terms of helping people to have more secure jobs, helping people to do things that will make those jobs quality jobs that provide the basic needs that they have to get through these hard times. I think, when people like to focus and make this argument that I think is not really accurate, that unions are the reason why we have so many problems with the economy, and they'll point to auto or other industries, and they sort of don't notice when they're making those arguments all of the other non-union plants and shops and factories that are closing. You only focus on one where there is a union, and I think that's a big part of the problem. But I definitely think that ultimately, as much as folks want the bill to be cast as, unions, big unions trying to build union density or whatever, ultimately it's about what individual workers sitting out there in my hometown of San Antonio want to do to improve their workplace. And if we can't give people the basic tools to do that, then there's a real problem, especially when those are basic tools that are supposed to be guaranteed by international standards and things that we, even if you thought about it for a few minutes, would say, yeah, that kind of makes sense. Freedom of association, that's a good thing, isn't it? And so I think that when you sort of bring it back to that place about really what do workers want, and isn't this about letting them decide for themselves, that the question just looks very different.
Yeah, I'd have to agree with that. I mean, if we go back to the original National Labor Relations Act, I realize Willis here probably is opposed to that too, but when workers first got the right to organize, that was in the middle of the Great Depression, 1935. I realize there's some folks there who are now trying to make the case that that made things worse, just like the rest of the New Deal. It's revisionist history, doesn't have a lot of facts behind it, but people don't care about facts. Well, you can make that case. In terms of whether that would hurt the economy, as a purely practical matter, I'm as optimistic as anyone, but, let's say we get this law passed. Realistically, how many people are going to be organized? How long is this recession going to be? I don't think it's going to be that big a factor in terms of the outcome of the recession. But will it have a negative impact on the economy? We could point to unionized companies in trouble, but guess what? As far as I know, Citigroup doesn't have a lot of unions. AIG, does AIG have a lot of unions? Enron, I think that was one of the prize companies on those lists about a great employer. So they're troubled employers. Some of them are union, some of them are not union. And good companies work with their unions. Toyota is, by most lights, the best company in the world. Car company in the world. They have unions. Kia, Hyundai, they have unions. So this idea that somehow unions are going to make companies uncompetitive. Yeah, if you have bad employers, they'll be uncompetitive with the union. They'll be uncompetitive without a union. It's as good a time as any if we have the ability to get through. Would have been great if we'd done it 10 years ago. But, if we could do it this year, that'd be great.
Well, I'd love to cross-examine this guy, but this is apparently I'm not going to get that chance, so I'll let it slip. But I hope we get that opportunity. At least I get that opportunity one day. Look, let me interject. I'm not a politician or a legislative analyst or anything like that, but let me interject a note of real politic here. This isn't about employees. This is about unions. By the way, I get it. I get that. The union movement spent millions and millions of dollars to get this administration elected. Millions of employees, union members, worked hard to get the current Congress elected and to get this president elected. It's payback. I got it. I understand it. It may not be, perfect. It may not be whatever you think it is, but it's real politics. That's what happened. It has to do with giving back to those people who supported this administration. It has to do with union density. There are all kinds of surveys, about whether employees want unions or whether they don't want unions. And I can point to surveys where, 3,000 people, where 82% don't want unions. Look, this is about unions. And if you talk about the economy, you really have to look at this first contract arbitration provision, right? This provision could only have been drafted by someone who has never even seen a collective bargaining agreement, much less ever worked with one, tried an interest arbitration, or had anything to do with administering a collective bargaining agreement, which, frankly, I've done for 35 years. Look, the statute doesn't even describe what kind of arbitration it would be. Would it be baseball arbitration, final offer arbitration, where the parties, make their best offer and the arbitrator chooses? Do they, would it be tripartite arbitration? Well, the answer to that from the proactive people is, we'll just have standards. We'll talk to the board and we'll have regulations and we'll have standards. Well, there can't be standards. There's no such thing as standards in collective bargaining. I mean, when an employer negotiates, when the language is to his or her benefit, you tell the union, this is standard language, give it to me. When the union has language that's good for it, it says this is standard language. Each party's right when they say, no, there's no such thing as standard language. A collective bargaining agreement in a heavily organized industry will have 200 entries in the index alone, okay? So what's a standard successorship clause? What's a standard no-strike clause? What are you going to do about multi-employer pension funds that are underfunded? Is an arbitrator going to be able to put people into that? What about single-employer pension plans that is an arbitrator going to force an employer to have a certain kind of pension plan, defined benefit, defined contribution? What about basics things? What about grievance procedure and arbitration? What about overtime? What about hours of work? What about distribution of overtime? I mean, we're just going to give this in this statute to who? Which is the last point I'll make. In major arbitration cases with very skilled union advocates, lawyers who I respect and have dealt with for years, we, in good faith, have taken months to determine who an arbitrator would be. And there's a reason why that's the case, and that is because there aren't enough good arbitrators to handle really important cases. So even assuming that people who are thinking about standards here, and they can't be thinking at all about standards in any serious way, could come up with something, there's nobody to do it. There's nobody to do it. The Canadian example is rife with litigation. There are multiple examples of provinces in Canada that started off with first contract arbitration that have since abandoned it. Nova Scotia, New Brunswick, and I think Alberta don't have it. Once did. I mean, this is a complete hornet's nest that nobody has given any rational thought to. And if that is going to help the economy, then how? I mean, it's ridiculous.
Julia, do you want to respond to the arbitration comments?
Which part of it? I want to go a little bit back to the statement about sort of our characterization of all employers as bad, because it really is so not the case that the way my organization works is to characterize employers as that. In fact, one of the first things that we did was bring over to our staff somebody from the socially responsible investing world who used to work at Calvert to come in and help us to find ways to really highlight where you had good labor management partnerships and to cast a positive light and bring positive attention to those employers that really are doing it well. And each year we publish about a report that has about a dozen companies that happen to be the ones that make it on the list that year that are engaging in really positive labor management partnerships. I think that's a really important thing for people to keep in mind is that I made this statement in the formal remarks at the beginning, but there are over 500,000 employers who over the past 5 years have voluntarily recognized unions in their workplace without making the employees go through some rigmarole process. And that's a really significant thing. There are lots of employers. I take issue with the argument that there is unanimity within the employer community on this because we see, time and time again, employers who really don't see that it meets their bottom line. They see a lot of positive reasons for why they would work with a union hand in hand. You see a lot of good ways that unions actually can help employers, and it's particularly true for small businesses, although folks keep trying to talk about the terrible things that would happen if this act were passed to small businesses. In fact, many small businesses are able to provide health insurance to their employees because even though they couldn't afford to create a risk pool on their own where they could provide affordable coverage, by having their workers be part of a broader pool of workers through their union, they're able to provide that. There are lots of examples of training programs, particularly apprenticeship programs in the skilled trades for plumbers, electricians and whatnot, where the small employer is not going to be able to, run a whole training program to really get all their people up to speed and to be able to be competitive with those bigger businesses. But by having a union in place, they get access to those training programs that are, in fact, some of them, there's countless research on this, those are some of the most effective training programs that exist in the country. So to that end, I just want to say it. On the arbitration piece, again, I'll just go back to the actual text
and Julie,
of the bill.
if you can be very quick here so we can get people a chance
Sure,
to ask
of course.
questions.
The bill does not impose any time limits on how long people can keep the process moving. If either party can choose to say, look, this is just going nowhere. There's nothing. It's funny because I actually have negotiated contracts on the side of management. I know how this works, and it is not some sort of situation where people don't know this is not moving forward because the other side is being recalcitrant. That can happen on the union side. That can happen on the management side. And frankly, I'm kind of surprised that more management attorneys aren't interested in using this to help just bring closure. If there really is a provision of a contract that workers are just hammering away that we must have this, the employer already has the ability to open up its books to a third party to say, look, this is just not doable. I cannot meet my bottom line. Nobody here is going to have a job if we use this contract term. And it will not happen. So there's sort of this, fairy tale land world being created where suddenly companies will be unable to, be functioning, going enterprises, and that's just not the case.
Thank you. With that, I'm going to, sorry, I know the panelists wanted to jump in on other points, but I'm going to have to open it up for questions from the audience. Start with one from this side and the woman in the red right there, and then.
I found this panel discussion very stimulating. I want to offer a hypothetical. What if the bill...
And sorry, if you could introduce yourself.
I'm Jane.
And
I work with the National Labor Relations Board. I just want to introduce a hypothetical. What if the bill only had the third feature, the strengthening the enforcement of the National Labor Relations Act, and that was the entire bill? What would the panel's comments be, pro and con, on that bill?
We'll start with Julie and then work our way down.
I think it would not be it would not have a significant. It wouldn't be able to deter problematic behavior that we see happening, in and of itself. And the treble damages right now, so for people to know, damages in back pay awards average, and I believe it's the mean, are about $4,200 a year. So if you're we could go to one extreme. If you're Walmart, if you're just a giant grocery store here in town or whatever, $4,200, that's nothing, right? So 3 times $4,200 is still not a lot. And the possibility of, up to $20,000 in the civil penalties is still probably not going to be a big enough hit to the pocket. I was a plaintiff's attorney before going back to grad school to do my PhD. And I mean, the importance of having significant financial hits on the line if you are doing something that is in violation of the law, I think is critical. And so the way that the bill is drafted right now, that provision alone, I think, would be insufficient to make the kind of impact that's needed.
Yeah, I'd just quickly say I agree with that. I mean, it would be good to have a more serious sanction because I think as it stands now, it's true it's a joke, but it would not prevent, if you're looking at a big organizing drive and you really don't want a union, it's not going to prevent an employer from wrongfully firing a worker.
Willis?
I guess it doesn't say much for the drafters of the bill that the third piece of it, which has to do with penalties, is a joke. I assume that they actually gave some thought to it before putting pen to paper. Look, it's difficult to separate out the pieces of this, frankly. But any statute that's been around, I'm speaking just for myself, not for Jones Day, not for any company I represent. It's difficult to say that with respect to any statute that's been around for 65 years, I can't do the math in my head, that it shouldn't be looked at in terms of any aspect of it. It's just that what we're looking at here is an integrated whole. I agree with Julie on that. And I don't think you can separate it out. It's kind of a conversation for another day.
All right. Let's take a question from this side. Gentleman right here in front. And if you could, again, identify yourself.
Do I have to stand up?
That would be helpful so other people can see.
Yes. Good afternoon, ladies and gentlemen. My name is Roderick Woodson. I'm a partner at Holland & Knight. It has been provocative and stimulating. I'm also impressed that you have a 3-to-1 ratio here. Sometimes it'd be better if it were 2 to 3 or 3 to 3. That would be helpful. I have two things. One is with respect to apprenticeship training. I've been taken with this notion that union apprenticeship is the end and all and be all of skill training. It is not. I deal with apprenticeship training regularly here in this metropolitan area. Unions have no monopoly on that kind of training. With small businesses, the issue is not union membership in pooled benefits. It's the impact of workplace rules. That's the challenge for small businesses. But my question to you is, it has not been really answered in your discussion, and that is why there has been such a decline in union membership. The companies, and I have interacted with a number of non-union companies and union companies, it seems that the unions really, in the organizing effort, the challenge is what do the unions have to offer that improves the lives of the workers? In the companies that I have dealt with, the companies provide a good benefit package. They provide a good retirement package. They have prevailing and competitive wages. What did the unions offer other than take their money out of their paychecks every week on their dues?
So let's
that's
take,
my question.
let's take the question, which is why has there been a decline, which I think many of our panelists sort of addressed, and that was sort of one of the fundamental debates here is what's driving this. So I'll give you a quick chance to recap your arguments there.
All right, well, just quickly, as I say, you don't see it in the public sector, and contrary to what Willis said, public sector workers very often compete. Now, I don't know where he's been, but it's very standard now for public sector workers to have to compete for their jobs against private contractors. And in fact, the recent issue has been the Bush administration, to give contractors to their friends, often tilted the deck in their favor. So public sector workers do compete, and in the public sector world, you have unionization rates on the order of 36, 37%. We also know that there's a lot of data on this, and maybe my friend here will dispute it, but I think I'll have a hard time. Unionized workers do get a premium on the order of 12%. It's higher for women, higher for minorities. They're far more likely to get health insurance. They're far more likely to have a pension at their workplace. So there are real benefits offered to unions, union membership. Obviously also having representation at the workforce, so you can't be fired arbitrarily by your employer, which they can fire you under current law. Of course, your employer can fire you any day of the week for any reason they like, except a very limited subset of categories. So unions offer a lot of benefits that public sector employees seem to value. I guess as private sector employees would value them as well, but private sector employers are very hostile to unions, and that, to my mind, explains the decline in unionization.
Look, I really don't think it's ideological. There are employers that, and it's often said in the management bar that unions don't organize employees, employers organize employees, and that's true. And there are any number of employers that are bad employers, that do bad things to their people, that are not contributing in any way to their employees or their communities. And those are the employees, those are the employers, I think, that get organized. But there are several phenomena here. You know, one is the fact that the money part is the easy part, right? I mean, if you're an employer, you look at the comparables, and you make a judgment about in terms of what other employers pay, and you try to meet or exceed, frankly, right? The union wages, and that's good for the employees, good for the company if you can afford it, bad for the unions in terms of organizing. The second phenomenon that's about a 25 or 30 year phenomenon. You know, if we were having this discussion 25 or 30 years ago, we'd talk about dignity in the workplace and that sort of thing. You've got a gigantic plaintiffs bar that can take and represent employees in all manner of workplace disputes, age, race, sex, discrimination cases, wage hour cases, and in many ways the plaintiffs bar has supplanted the need for unions, and there are lots of there are a lot of legal issues having to do with that, as you know. I mean, there's the role of arbitration versus the role of litigation, and how they interact with one another. So there are a lot of things. Globalization's another reason. I mean, there are any number of reasons, but it's not, at least in my experience. Look, I'm not naive. There are some bad employers who will fire the union organizer. All this assumption that that's what employers regularly do is just wrong. Just wrong. In fact, most union organizers identify themselves as such. They walk into the HR department and say, I am the union organizer. They're protected, no matter what they do.
And Carol, I know you were jumping and trying to get it in on a different point, but I'll let you get in now, and then we'll get to another question.
Okay, I mean, I think one other reason potentially for the decline is the decline in protections for workers' right to freedom of association under U.S. law that we have seen since the passage of the Wagner Act. As was mentioned when the Wagner Act was passed, for about 10 years after its passage, employers were required to recognize unions based on card check, and employers were barred from campaigning against union formation. The Taft-Hartley Act passed in 1947 was largely a response to this, and the Taft-Hartley Act gave employers the right to reject a union's request for recognition based on card check. But even a few years after Taft-Hartley, the board and federal courts still recognized the right of union representatives and workers to respond in kind to employer anti-union campaigning. So there was more of a balanced playing field. It is through the jurisprudence that we've seen come down from the National Labor Relations Board and from courts over the years that have eroded the right of workers to respond and have eroded other protections. And for example, the issue of whether or not an employer's anti-union speech is coercive. I mean, I think Willis mentioned this several times, that employers can only campaign against union formation through non-coercive speech. Well, a non-coercive, I guess I would see it as a threat, but an employer can say, it's likely that if a union forms, the costs are going to go up so much that we're going to have to close. That's legal. An employer cannot say, if you form a union, I will move shop to Mexico, or I will pick up and go elsewhere where there will not be a union. That's illegal. But it is not illegal to predict what may occur. Now, that distinction between a prediction and a threat that a business will close is lost on workers. I mean, they're going to think, oh my goodness, the employer is saying that it's likely this might happen because of X, Y, and Z. Then that has virtually the same effect on a worker as a straight-out threat saying that the company is going to close or move shop overseas.
I don't want to give legal advice here, but an employer cannot say it is lawfully that it is likely that this shop will close
down.
It is
possible. Likely possible. The employer can suggest that because of possible increased costs from a union, that closure may occur.
I mean, but that's let's take the reasonable man standard in tort law. I mean, that's why we have laws and cases and facts.
But the worker on the shop floor doesn't know those laws and cases and facts.
Perhaps more importantly, that statement does not have to be based on fact for it to still be legal.
Yes, it does. It absolutely does.
They have the employer, before a union is recognized, has no idea what amount of money will go into that contract that they sign for wages. So how could they possibly know and base that on fact?
Well, first of all, half the time, if not more than half the time, they're responding to what the union has said in the campaign. So if the union says, I'm going to raise the wages by 50%, an employer can respond.
Let's go to the questions. The gentleman in the suit right there has been.
Hi, I'm John Rodabaugh. And a couple of years ago, I was entering Westminster Abbey and paying for the admission, and I was told, oh, you're elderly, so I'm over 60. And I'd like to begin by saying it's wonderful to have debate, and I've been guilty of what I'm about to say. But I think we need decorum, not that there isn't here, but we need to maintain decorum when we discuss things and go to hearings and stand up and leave when another witness is about to talk and interrupt discussion. It's juvenile and junior high school, and everybody knows it. Number two, we need transparency. When we have all this number of articles coming out, we need people to identify, were they paid to write the articles? If so, by whom?
Could you please ask a question?
You know what? If you don't mind, I will continue. We need data. And my question is leading up to, as everyone else has commented here, to eliminate the National Labor Relations Board in its entirety and take this all to federal district court. I am asking you to do that because it's inappropriate for a sitting adjudicator to comment in public forums about the deprecation and how horrible the statute is. It's impossible to litigate a case before the agency when we have human beings who have opinions who can be biased. Let's take it before judges, get away from the politics, and get on with fairness in the workplace. And by the way, the United States of America, although it doesn't endorse the two conventions you're referring to, there's many countries who have adopted it and criminally violate laws day to day. I do hope that even though you did go to Harvard, that you'll recognize that this country is a pretty good place. Thank you.
Yeah, I'm not sure there was the question. Perhaps was if you would eliminate the NLRB. And if anyone wants to respond, feel free.
I don't have an opinion on that.
Can I just respond to U.S. international obligations?
Sure, and then I'll take a question from the back of the room.
He's quite correct that the U.S. has not ratified ILO Conventions 87 and 98 on freedom of association and the right to collective bargaining. The U.S. has ratified the International Covenant on Civil and Political Rights, which also recognizes workers' right to organize, and has recognized the jurisdiction of the ILO Committee on Freedom of Association, which has stated, quote, that when a state decides to become a member of the organization, that being the ILO, it accepts the fundamental principles embodied in the Constitution and the Declaration of Philadelphia, including the principles of freedom of association.
All right, we have time for one.
I am going to come in, actually. It's. Is
Wait,
there a
hold on.
question?
I'm not taking questions that are just shouted out. So let's let.
I don't even know who's asking.
Yeah, well, just in response to that, if you want to know if they paid for our study, no unions gave any contributions to the Center for Economic and Policy Research, so no, they
not
did
for
not.
Human Rights Watch either, no.
That was your question.
American Rights at Work is very proud of the fact that we are financially supported by a number of unions. And my work that has, I think, been mentioned at various points in time comes from that.
And we have time for one last question from the gentleman at the very back of the room, and so please keep it very brief.
Mr. Goldsmith, you saw the movie Casablanca, and
you must be about my vintage.
And you recall when someone tells the police captain that there's gambling going on in the back, he says,
Shocked.
I'm absolutely shocked.
Shocked.
And that's the reaction I had when you said that there was unanimity among the employment bar that you were opposed to the Employee Free Choice Act. Although, ironically, you're going to benefit from it because all of these non-unionized employers are going to come to you at $900 or $1,000 an hour and have you work with them.
From your lips.
More importantly, I've tried maybe close to 1,000 RC cases before the board. I know that any lawyer, even a moderately competent lawyer, and you're certainly not in that class, can delay an election from...
I'm not sure I know how to take that.
from 2 to 4 years, maybe 6 years. The fact that you cannot get an election, that's what the problem is, and that's what gives rise to the Employee Free Choice Act. If you will, take a look at the public sector, where employees are on a level playing field, and they have that opportunity in the Northeast sector for the most part. They are organized. They're not organized in the South because there's no enabling legislation. And I suggest to you that the real problem is not the act, but what motivates the act, and that's the inability of the employees to get a prompt election.
You know, I'm glad you raised that question. It's one of the points I didn't get a chance to make in my presentation. Let me give you some data from the General Counsel. First of all, in 2006, 94.2% of the representation elections were held within 56 days. The median was 39 days. In those cases, in 2006, unions won 60% of the time, as compared to 1985, where unions won 48% of the time. In 2007, unions won 57% of the representation elections. And in the period from October 07 to March 08, unions won 62% of the representation elections. So they both happen pretty quickly, and unions win more often than they lose. And by the way, union density actually went up in 2008 from, I think, 12.1% to 12.4%. Yeah, those are numbers. That's what we're talking about. Well, there are 428,000 more union members today than there were at the end of...
Mostly public sector.
Okay. Well, I'm talking about the NLRB. The percentage statistics were labor board, private sector elections. The only other thing I'll say about unanimity is also we have on the unanimous side Warren Buffett, George McGovern, and Al Sharpton. That's not easy, you know.
And I'm going to let Julie get the very last word in here because she happens to be next to me and was egging for it. But
Well, only because I gave an incomplete or wrong answer. So I said I didn't have an opinion on the abolishment of the board, but I do want to make it clear, and I say this as a former plaintiff's attorney, if you did not have a statute that explicitly prohibited firing workers for union activity, you would have no protection for workers. And so I would not support that. I can't tell you how many times I sat at my desk when I was a plaintiff's attorney and had people come into my office saying this terrible wrong was done. I have been an excellent employee. I've shown loyalty. I've done hard work. I've gone above and beyond. And they fired me because of X. And we all know in this room that unless it's for one of the, by statute, designated reasons, there is nothing that any attorney can do for you. Were it not for us having the NLRA or something that similarly takes a very active role in protecting that right that I think we do all share, the view is an important one, we would not be able to have anybody in this country safely exercise that right.
Thank you, Julie, and thank you very much to all of our panelists. I really appreciate this excellent discussion you've been able to help us have.